statement for today. Secretary General.
Consideration of bills.
Honourable members, I now call upon the Honourable Attorney General and Minister for Justice, the Honourable Siromi Turaga, to move his motion.
Mr. Speaker, sir, pursuant to the resolution of Parliament on Monday, 3rd of April 2023, I move that the Media Industry Development Repeal Bill 2023 be debated, voted upon, and passed.
Is there a second now?
Honourable Speaker, I second the motion.
Honourable members, please be reminded, pursuant to the resolution of Parliament, the debate on this bill will be limited 1 hour. And I now call upon the Honourable Attorney General to speak on his motion.
Mr. Speaker, sir, I rise to contribute to the debate of the Media Industry Development Repeal Bill 2023, otherwise known as Bill, which was tabled in Parliament on Monday, 3rd of April 2023. The bill seeks to repeal the Media Industry Development Act 2010, which I will refer to as the Act. Before I touch on speaking notes, Mr. Speaker, sir, may I be guided? The words of wisdom from Isaiah 10:1-2 says, "Woe to those who make unjust laws, to those who issue oppressive decrees, to deprive the poor of their rights and withhold justice from the oppressed of my people, making widows their prey and robbing the fatherless." Mr. Speaker, sir, this verse highlights the importance of just laws and the protection of rights of all individuals, including journalists and media organizations. Mr. Speaker, as I mentioned on Monday, 3rd of April 2023, the Act was proclaimed as a decree in 2010. It regulates, amongst other things, the ownership, registration, and content of the media organization in Fiji. The Media Content Regulation Framework includes the creation of a Media Industry Development Authority, the Media Tribunal, and other elements. This makes up bulk of the Act, and it is these aspects that are considered controversial. These elements have been considered as hindering the growth and development of a strong and independent news media in Fiji, and a breach of the constitutional right to freedom of expression as outlined in Section 17 of the 2013 Constitution of the Republic of Fiji. Mr. Speaker, sir, on the issue of the Act hindering the growth and development of a robust media industry in Fiji, the following observation was made by the Multinational Observer Group, MOG, in its final report on Fiji's 2022 general election. I quote, "The MOG spoke to a range of media organizations and said that they are committed to reporting news as they saw it. However, they advised that there was a culture of self-censorship, especially among young journalists. Most media sources advised that the potential for and severity of the penalties under the Act was a cause of significant concern. The MOG heard from a range of media organizations that uncertainty and confusion about the application of the legal framework impacted their willingness to report on some issues," unquote. The MOG also observed there were reports from stakeholders of a more restricted media environment, were consistent with the Fiji's recent decline in the Reporters Without Borders World Press Freedom Index. Fiji was ranked 57 out of the 180 countries for press freedom in 2018, but fell to 102 in 2022. It is the lowest ranking since 2014, and making Fiji the lowest ranked Pacific country. Mr. Speaker, sir, it is precisely these issues that the bill seeks to rectify by repealing the Act. The media industry, and by extension, the dissemination of vital and relevant information to the public, must be carried out in an environment where there is no fear of the unknown. Even if the information be disseminated is contrary to policies and aspirations of the government of the day, media rights must be observed. It serves for nothing but the detriment of the people and the country when the media laws are necessarily restrictive. Mr. Speaker, sir, the Act does not and has not served any practical purpose other than to unnecessarily limit media organizations in their operations and freedom of expression that is the hallmark of a democratic country. While the Act established the Media Industry Development Authority, the existence of this body in recent times has been in name only. Mr. Speaker, sir, the Media Industry Development Act, the authority, does not have any staffing, neither it is performing the totality of its functions as mandated by the Act. This was also stated by the MOG in its report, where it observed that the Fijian Elections Office had taken over some roles it had previously shared with the Media Industry Development Authority, such as media accreditation, and has taken on a monitoring role, such as requesting that the media issue retractions or corrections using the newly created offense on publications of false statements as provided for under the Electoral Act 2014. Furthermore, Mr. Speaker, sir, since its establishment and for the first 8 years of its existence, the Media Industry Development Authority failed to provide an annual report as required under Section 15 of the Act. It was only in 2019 that a consolidated report for the periods 2010 to 2018, that is 8 years, was tabled. Since then, in clear breach of the requirements of Section 15, no other annual reports have been tabled. Mr. Speaker, sir, the Media Tribunal was also established under the Act to hear complaints referred to it from the Media Industry Development Authority. However, the Media Tribunal is virtually defunct as its members were never appointed. The Act also provides provisions for the regulation of the content. Under the Act, publication must not include material which is against public order, national interest, or create discord. With no definition for what exactly may constitute public order and national interest, this provision has been seen as a thinly guised attempt to suppress the media. Mr. Speaker, sir, when the Act was first proclaimed in 2010, it was done so in a rushed and hurried manner. As reported in the Fiji Media Industry Development Act 2010, an analysis from Dialogue Fiji, and I quote, I attended the launching of this report. Media organizations and journalists were summoned to a super holiday inn in April 2010 and given only 2.5 hours to read the 50-page draft before being asked for comments and submissions. The then Attorney General, Syed Qayyum, told assembled media that the proposed decree was not a debate. Suspicions that the decree was faith comply were vindicated when the proclamated version turned out to be almost identical to the draft, save for a few minor adjustments, unquote. Mr. Speaker, sir, prior to this bill being tabled in Parliament, we had also conducted public consultations of the review of the Act on 23rd of March 2023. Apart from members of the media industry, the public consultation was attended by representatives from the UN agencies, civil societies, the RFMF, FCCC, Consumer Council of Fiji, and members of the public. Mr. Speaker, sir, if I recall correctly, the leader of the opposition in his contributions before the August House on Monday, 3rd April 2023, had mentioned how we had prepared a different draft bill and following the consultations, and bowed to the press of the media organizations, introduced the bill that is currently before this August House. This may come as a surprise to him, but essentially, that is how democracy works. You listen to the views of the people, and where necessary, and within reason, make the necessary policy and/or legislative changes. Mr. Speaker, sir, it would be prudent to consider the Act not only from the viewpoint of the coalition government or the Fiji First government, but in consideration of an instance where a more aggressive or unsympathetic government were to assume leadership. If this were to be the case, what guarantees is there that a much stronger stance would not be adopted in implementing the Act? In contemplation of this, it is imperative that the Act be repealed. Mr. Speaker, sir, with the repeal of the Act, this does not mean that the media has the unfettered right to report on anything and everything without verifying the veracity of the information. Moving forward, the media industry will regulate itself with setting up of a Fiji Media Council. Mr. Speaker, sir, the repealing of the Act does not mean that the ordinary person will not be able to raise the grievances on unscrupulous or uninformed reporting or publication by media organization. Redress is available through the existing legislation such as the Defamation Act of 1971, the Online Safety Act of 2018, and the Crimes Act of 2009, amongst others. In fact, Mr. Speaker, sir, my predecessor, Mr. Kayum, during his term as Attorney General, had instituted committal proceedings against Fiji Times Limited regarding the publication of an article. The matter was appealed to the Supreme Court. However, it does not negate the fact that even with the Act in place, there are other avenues within which grievances regarding media organizations were addressed. Mr. Speaker, sir, consultations were held with the Ministry of Communication, members of the media industry, and the Office of the Solicitor General. I would like, Mr. Speaker, just to briefly outline some of the salient features of the bill. Clause 1 of the bill provides for the short title and commencement. If passed by Parliament, the new legislation will come into force on the date or dates appointed by the Minister by notice in the Gazette. Clause 2 of the bill sets out the definition of the terms used throughout the bill. Clause 3 of the bill provides for any action, arbitration, proceedings, or cause of action pending against or in favor of the authority to continue against or in favor of the ministry responsible for the administration of the new legislation. Clause 5 of the bill provides for the consequential amendment to the following laws to cater for the repeal of the Act: the Electoral Act 2014, the Television and Online Stream Act 1992, and the Financial Management Responsible Authority Regulation 2019. My concluding remarks, Mr. Speaker, sir. In the book of Proverbs, it's written, "The tongue has the power of life and death, and those who love it will eat its fruit." Proverbs 18:21. This verse emphasizes the importance of responsible speech, but it also recognizes the power of speech as a means of communication and expression. Furthermore, the Bible encourages us to speak for justice and righteousness. In Proverbs 31:8-9, it says, and I quote, "Speak up for those who cannot speak for themselves, for the rights of all who are destitute. Speak up and judge fairly. Defend the rights of the poor and needy," unquote. This verse highlights the importance of speaking up for those who are marginalized and oppressed and are advocating for their rights. Additionally, the Bible also highlights the importance of being open to criticism and correction. Proverbs 27:17, it says, and I quote, "As iron sharpens iron, so no one sharpens another." This verse emphasizes the importance of constructive criticism and dialogue as a means of improving oneness and society. These biblical references remind us of the importance of free speech, responsible communication, and the role of media in promoting justice. While there may be limitations to free speech, it is essential to ensure that any restrictions are balanced with the responsibility to speak up truth, for justice and common good. Accordingly, Mr. Speaker, I commend this bill to Parliament. Thank you, Mr. Speaker, sir.
Thank you. Honorable Attorney General, honorable members.